Anastasia Fainberg, attorney and founder at Legacy Law Group Colorado, and today I want to address the most popular question that we get asked when it comes to estate planning. And that is, should I get a will or should I get a trust instead? And what is really the difference? So what it really boils down to is the smoothness and efficiency of estate administration. At Legacy Law Group, we believe that estate planning is not something that you do for yourself. You really do it for those that you care about the most. It's really about the people that are going to be left behind if you're no longer here, that are going to be in charge of administering the plan or lack thereof of what you've left behind. So if you are thinking about making it as smooth and as efficient as you can for those people that are going to be left behind, then here's what you have to look at. If you were to just do a basic will, which a lot of people rely on, the major disadvantage of that will is that that will have to enter probate. So probate is a court process during which a judge gets to basically run the process and make sure that the will is valid, and then make sure that the entire probate process goes smoothly. So you're putting your loved ones onto the court's calendar and on the court's timeline. And with all of the recent delays that we've had because of COVID and other factors that are affecting the efficiency of courts, relying on a court calendar may not be very efficient or very convenient for your loved ones if they had to administer your estate. On top of that, there's a lot of statutory requirements that are creating delays for your loved ones. For example, they will have to publish a creditor notice and have that run in a local newspaper for 4 months. And they can't really do anything with the estate until all of the creditors are satisfied. So with probate, with the basic will, you're putting your loved ones in a position where they would have to go to court, they would have to be governed by the court's timeline, and they will have to be delayed by all of these statutory requirements to make sure before they can go ahead and distribute everything out of your estate. With the trust, the way we create revocable living trusts here at Legacy Law Group, we make sure that all of the assets that you currently own when you're living are owned by this new entity that you're setting up, which is the revocable living trust, so that when you die, nothing is subject to probate because the dead person doesn't own anything at that point. The trust is a new legal entity that owns all of the assets that you used to own when you were alive. And so that means that a properly created revocable living trust will let your loved ones stay out of court completely because all of the assets will be immediately available to your loved ones. What a lot of estate planning attorneys fail to account for is how does your trust own all of the assets that you have. So a lot of the times clients come to us and they have already executed an estate plan with another attorney, and then when we ask them, well, is your house owned by your trust? Are all of your bank accounts owned by your trust? Do you have your trust listed as a beneficiary on your life insurance? Sometimes a lot of our clients don't even know that that process had to take place after they signed their trust. Because it's very easy to say in a will or in a trust that I want everything to go to my spouse or my kids, but how will your trustee or your personal representative know what that everything really is? So here at Legacy Law Group, we make sure that we literally hold our client's hand to make sure that we account for every single asset, and that's spelled out in their trust to where the successor trustee can easily see the entire estate, what accounts, what financial institutions, what real estate, LLC, see all of the structure and really administer it with ease and time efficiency in the best possible way. So that's kind of a pretty long explanation for why most of our clients choose to go with the revocable living trust. But basically, I hope I answered your question of what the difference is between a will and a trust. And if you would like to set up a consultation and speak to us about your particular estate and what would be a better option for you, please give us a call at 303-954-9428 to create your complimentary family wealth planning session.